Good morning, ladies and gentlemen. On behalf of the European Judicial Training Network, the EJTN, it's our pleasure to welcome you at this webinar, the European Investigation Order, Perspectives and Challenges for Practitioners. My name is Sára Sipos. I'm a project manager at the EJTN. I shall be your moderator today. I'm joined here in the studio by my colleague, Michael Korhonen, who is EJTN's communications manager, and by my other colleague, Barbara Kovács, who is a learning coordinator at the European Union Agency for Law Enforcement Training, the CEPOL.
Good morning.
Good morning from me as well.
I would like to share a few words about the EJTN with you. The European Judicial Training Network brings together judicial training institutions from all the European Union member states and supports the interest of over 120,000 European judges, prosecutors, and judicial trainers across Europe. The aim of the EJTN is to help foster a European area of justice and to promote mutual recognition and trust between judicial systems and practitioners. Focusing back on today's webinar, it is in fact EJTN's first pilot webinar. It has been produced with the invaluable expertise of CEPOL and hosted at CEPOL's facilities. EJTN is grateful to CEPOL for its long-standing support and partnership. And we are particularly grateful to CEPOL's e-learning coordinator, Barbara Kovács, for her support, guidance, and unending patience. I would like to say a few words about the housekeeping rules to guide you through some of the practicalities of this webinar. On your screen, you will see the little panel on the right side where you have different options for making screenshots of your PowerPoint slides. You see the yellow box. If you click on the little orange arrow, you can open and close your panel. And then you can view and select your audio settings. Your microphone should be on mute. And you can submit questions to us in this little pane where you see questions above. You can type in your questions.
Maybe we can practice a little bit. Sára, what do you think? We can invite participants to use the question pane.
That would be a great idea. So we would have a quick question to test today. If you could share with us which country are you coming from, which country are you joining us from, and you could type in the pane, that would be great. I already received responses. I see participants from Greece, Czech Republic, Poland, Italy, Hungary, Slovakia. Wow, this is impressive. We have a really pan-European webinar here. Bulgaria joining as well. Thank you for sharing with us where you're coming from. This event is recorded and will be available as a recorded webinar on the webinar resources of CEPOL's ENET and will also be uploaded on EJTN's website.
This is just a short demonstration how people can access the recording later on, which will be available approximately in a week. And this is the certificate slide I skipped, Sára, because you wanted to notify participants about the certificate, I guess.
Yes, it's another important housekeeping issue. For those of you familiar with CEPOL's webinars, please note that we won't be issuing post-event certificate for this pilot webinar. I wish to draw your attention particularly to the last point of the program, the closure and evaluation. When the webinar is finished or when you leave the webinar, an evaluation form will open on your screens. Please do complete this evaluation form, as the received feedback will help to determine and shape EJTN's future webinar program after this pilot webinar. So that would be we would be thankful if you could complete this evaluation for us. Our webinar's presenter today is Mr. Daniel Bernard. He's a magistrate honoraire, a former federal magistrate in Belgium. Daniel Bernard was working as a prosecutor since 1986 until his retirement in 2016 at the Belgian Federal Prosecutor Office. Active in the field of international cooperation since 2002, he was the European Judicial Network, EJTN's contact point, and spent 4 years at the Belgian desk at the Eurojust after being a liaison prosecutor in Morocco for 3 years. I would like to give you a brief overview of today's session. The European Council called for a new approach in order to replace the existing EU framework for the gathering of evidence. From 22 May 2017, one single instrument called the European Investigation Order, based on the principle of mutual recognition, will replace between the EU member states the traditional mutual legal assistance request in the area of gathering of evidence. The aim of this presentation is to show you the main changes and innovations introduced by the European Investigation Order in comparison with the two main existing instruments in mutual legal assistance, the Council of Europe Convention of 1959 and the EU 2000 Convention. Now it's my great pleasure to turn this webinar over to our presenter, Mr. Daniel Bernard.
Good morning to all of you. I can't see you, of course, but with some problems, I cannot act myself my PowerPoint, so you will hear that I will instruct Budapest, because I'm in Brussels here, to change the slide. So don't worry about that. If you are active in the field of international cooperation in criminal matters, you are very familiar with the so-called rogatory letters or mutual legal assistance requests exchanged between the EU member states. This will change from 22 May 2007 in 1 month for the most of the member states. On this date, the last EU instrument based on the mutual recognition will enter in force, the European Investigating Order, or EIO. The aim of this presentation is to help you to discover the main changes, the main principles of the EIO as indicated in the directive of the EU Parliament and the Council of 3 April 2014. Of course, due to the allocated time and the absence of practical cases to illustrate the theory, many questions will stay open, and probably I would not be able to answer all your questions. So, the next slide, please. So, first of all, I want to situate this new directive and this new instrument in the general landscape of the international cooperation in criminal matters. First of all, the legal framework outside and inside the EU, you have bilateral agreements, regional international conventions like Benelux between Belgium, Netherlands, Luxembourg, Schengen, Prüm, and so on and so on. Then you have the EU conventions like the 2000 Convention, well known by you, the EU framework decision and directive, and here is situated the EIO. Then you have the Council of Europe conventions, and finally, worldwide, the United Nations Multilateral Convention. Next. Then you have the legal framework inside the EU. This is only what is used inside the EU, is of EU Convention from the Council of Europe and its two additional protocols. You have the Benelux Treaty, you have the Schengen Convention, you have the 2000 Convention, and then you have important framework decision regarding orders freezing property or evidence. And then from 20 May 2017, you will have Directive 2014-41 EU from the European Parliament and Council of 3 April 2014 regarding the AEO, European Investigating Order. All these instruments have to be read and used together when appropriate. You cannot use only the 59 inside the EU without using the 2000 Convention, for example. Next. Next slide, please. Okay. You have then instruments inside the EU that we use. You have the police channel, the Swedish decision. You will have, you can read it on the screen. Then you have the letter request. It can be used not only EU, but UN, Council of Europe, but between the member states, it will be replaced by the AEO. You have the freezing order, will be partially replaced by the AEO, you will see. Then you have other very interesting instruments inside the EU, the joint investigation team. You can use it also between UN convention, UN parties, member states, and Council of Europe. There is some examples. And then you have the AEO from 22 May 2017. Next. Okay. What will change? Between the EU member states, there will be a new instrument foreseen from 22 May 2017. Is the AEO. You can go to the hyperlink now, our AGN website, if you can show it. You use the full PowerPoint. Okay. In awaiting that we have the AGN website, normally the directive has to be implemented in the concerned member states for the 22 May 2017. But Denmark and Ireland are not taking part in the adoption of this directive and are not bound by it. But the United Kingdom has notified its wish to take part in the adoption and application of this directive. I know that actually in many member states, the procedure of implementation is ongoing. I have knowledge of already 2 published laws on the website of the Council of the EU, France and Germany. Maybe other, but yesterday I checked on the website and there are not actually other communicated laws. The AEO will be applicable only between the member states that have already implemented it from 22 May. For the other member states, the usual mutual legal assistance framework will continue. However, some member states will use the AEO form even with the member states that have not implemented. I know that in France, for example, they will use the AEO form that I will show you with the member states that will even have not implemented the AEO. But that will not be a problem because it's only a form and you can use all the information that you will find in the AEO form, you can find it in the normal letter request. Okay, I don't know if we can go now to the EJTN website. Otherwise, I will continue and I try to show you the website after. Okay, next slide, please. Can you change the slide?
Yeah, just a sec. We are having some difficulties, but we are going there. Just a sec.
Okay. First of all, what will change? The slide will come. Sorry for that. The relations to the other legal instruments, agreements, and arrangements. It will be the Article 1 of the AEO. Is it possible? The AEO directive replaces the corresponding provisions. Okay, I hope you see now. No, not yet. The corresponding provisions of the following conventions applicable actually between the member states. The Council of Europe Conventions from 59, the 90 Convention, the Schengen Agreement of 90, the Convention of 2000, but as I said, it replaces only the corresponding provisions. All what is not in the directive regarding the AEO will stay. That's not a problem. But the AEO will replace completely the framework decision from about the European evidence warrant. This European evidence warrant will not exist anymore, but only a few member states implement this European evidence warrant. I confess I never seen this document because Belgium have never implemented this AEO document. So you can then see two replacements. The AEO directive replaced the corresponding provisions of five instruments and of three instruments, and replace completely the European evidence warrant and replace completely the freezing, the framework decision regarding freezing of evidence, but only regarding the freezing of evidence. What is not included in the scope of the AEO directive, it is the setting up of JITs and the gathering of evidence within JITs. The JITs stay a lone instrument, not changed by the AEO. The cross-border surveillance, as referred in the Schengen Agreement, will not be replaced by the AEO. This will continue as actually. Okay, next slide, please. This is a completely new approach. It will be one single instrument, the European Investigating Order. Instead of the existing framework, which is too complicated and too fragmented. You have to put all things in a lot of instruments. This time we'll have one single instrument to gather evidence abroad. This is the only goal of the AEO, is to gather evidence abroad. It will be issued for the purpose of having one or several specific investigative measures carried out in executing states with a view to gathering evidence, including that is already in the possession of the executing authority. And the European evidence warrant has the goal to gather only the already in the possession evidence in the executing authority. But now the AEO will do both. And this instrument is based on the principle of mutual recognition. An issuing of an AEO, and that is new in the decision, in the directive, may be requested by a suspect or accused person or by a lawyer on his behalf. Within, you hear me? Do you hear me?
Yes, we can hear you, Danny.
Sorry, within the framework of applicable defense rights, of course, through the prosecutor or through the judge in charge. This AO cannot have effect or modify the obligation to respect the fundamental rights of court. This is Article 1 of the AO Directive. Next slide, please. If possible. Okay. What will show? The types of proceedings in the frame of which you can use AO. You will see in the next slide, I make a parallel between the 59 Convention and the 2000 Convention, above left or above right, and the corresponding article. This article will be replaced by the new articles of the AO Directive. First of all, criminal proceedings, like already say in the normal, like always now, proceedings brought by administrative authorities in respect of acts which are punishable under national law, and it was already foreseen by the Article 3 of the 2000 Convention, not new. But what is new now is C, is a proceeding brought by judicial authorities being infringement of the rule of law, not crime, but where the decision may give rise to proceedings before a court having jurisdiction. I can be administrative infringements, but when there is a competence of a criminal court to go in appeal, for example, to examine the appeal against this decision. And then, like already foreseen by the 2000 Convention, for the proceedings when a legal person may be held liable. This is not new. The only new point is C. We can come back later, maybe. Next slide, please. Okay. What will change concerning the issuing? 2000 conventions say nothing about that. The 59 conventions say in Article 14, there was a minimum of requirements for the content of the request. There was no mandatory form to use. You could only find on the EJTN website, on the compendium, an informal form for a letter request. It's not very used by the practitioner until now. And it will be normal because now Article 6 of the AEO Directive, the issuing authority has to use the AEO form. There is only one form. This form has to be completed, signed, and contained, and the content has to be certified as accurate and correct. Is it possible to go to the EJTN website? Because it will be very important to show to the audience where they can find the form. Is it technically possible or not?
Right now, unfortunately, we cannot access the website, but after the presentation, we will try.
Yes, we can maybe do everything after the. It's very important. I insist to have access to the EJTN website because there you will find the text of the directive and you will find the the AEO form, Annex A, B, and C. It's very important. You have to see it today before you leave. Okay, the AEO form can only be issued if 2 points. One, the issuing is necessary and proportionate. This is new. This was a best practice until now, but now it's mandatory. The issuing is necessary and proportionate, and this topic is mentioned at the beginning of the AEO form. Second, the investigative measure indicated in the AEO could have been ordered under the same conditions in a similar domestic case. These are the two obligations for the issuing authority: necessary and proportionate, and possible in a similar domestic case. Regarding the executing authority, this is also already new, and the red line in this decision is that they promote the direct contact and the direct consultation between executing and issuing authority in order to save all problems. So the executing authority may consult the issuing authority on the importance of executing the AO if reasons to believe that the conditions have not been met. And the issuing authority, after hearing the remarks of the executing authority, may decide to change the AO or to withdraw the AO. Okay, next slide, please. The transmission, what will change? In the 59 convention, you see above left, it was between central authorities, Minister of Justice, or directly if urgency. In the 2000 convention, it was direct between judicial authority or central authority for some specific request. And you could use Interpol channel. And now in the new AO directive, Article 7 and 8, the transmission can be done by any means capable of producing a written record. And it's a direct channel from the issuing authority to the executing authority. Some member states could design central authorities or still. So we have to respect the decision of the member state about the use or mandatory use of central authority in some cases. I know in Belgium it will not be the case. It will be directly to the prosecutor office, the competent prosecutor. The issuing authority may transmit AO via telecommunication system of the EJTN. This is new also, but I guess it's not yet operational. So we have to wait the practicability of this system. The issuing authority shall use eventually the EJTN contact points to try to identify the correct authority in the executing state, if they don't know who will be the executing authority. The issuing authority shall indicate when they issue an AO if already earlier AO in the same case were sent, and in which country and to which authority. And the issuing authority may address an AO which supplements an earlier AO directly to the executing authority while he is present in that state. For example, and this is a best practice that we already use actually, when a prosecutor of an investigating judge wants to assist to the execution of his letter request in another member states, when he is present in that member states, executing member states, he can immediately give an additional letter request to the executing authority of this member state. We will win time. It is already due as such. And now, next slide, please. The execution. In the Convention of '59, you have to give the widest measure of mutual assistance. In the 2000 Convention, they complete it by to tell you that you shall comply with the formalities and procedure expressly indicated by the requesting member state. Regarding the AO directive, the executing authority, and this is, of course, the mutual recognition principle, shall recognize an AO without any further formality being required and ensure its execution in the same way and under the same modalities as it was a local, a national investigation. Unless, of course, the grounds for non-recognition or non-execution that we will see in later on. The executing authority can so not give, you have to recognize the AEO if there is no grounds for non-recognition. And the executing authority shall comply with the formalities and procedure expressly indicated by the issuing authority, that's what already say in the 2000 Convention, unless that such formalities and procedure are not contrary to the fundamental principle of law of the executing state. This was already the case now. And last point, the executing authority shall return to the issuing state, the AEO, if it has not been issued by issuing authority as specified. It's not always easy to control the quality of the issuing authority, but it's a possibility. So next slide, please. Execution. And this is absolutely new in this AEO decision, AEO directive, sorry. I put on the slide AEO decision, but it's AEO directive, of course, sorry for that. This is absolutely new. You can recourse to a different type of investigating measure as the request. The executing authority shall have, wherever possible, recourse to an investigative measure other than that provided for in the AEO. When, first, this measure indicated in the AEO does not exist under EU law, does not exist under the law of the executive state. Second, if this investigating measure indicated in the AEO is not available in a similar domestic case. When you have faced these two requests, these two situations, you have to find another investigation measure to have the same results, and that is absolutely new. There is some exception where you never can refuse the execution. This, when the request is to obtain information or evidence already in possession of the executing authority, when you request, the request is the aim to obtain information contained in police or judicial databases and directly accessible, when it's the request to hear a witness, an expert or victim, or suspect or accused person, when you don't use any coercive investigating measure, and when it's only to identify a person holding a phone number or an IP address. In this sixth case, you cannot refuse the execution. Next, please. You can also recurse to another investigating measure, and this is also new, where the investigating measure selected by the executing authority would achieve the same results by less intrusive means than the investigating measure indicated in the AEO. For example, when I was at the prosecutor's office, I received some requests where they request house searches in bank institutions to obtain bank records. Of course, never we make a house search in a bank for this topic. We send only official requests from the prosecutor's office to obtain this bank data. So this was in this case already used. But now, if you can obtain the same results with non-coercive measures of less intrusive measures, like for example wiretap, and you make a telephone surveillance, for example, is less intrusive. You can do it if the results are the same. But after to choose this kind of executing measure, you have first to inform the issuing authority, of course. You cannot do that without informing the issuing authority. And this issuing authority can decide to supplement the AEO, to make an additional AEO, or to withdraw completely this AEO. And when it's not possible to provide assistance, the assistance requested, even when a different type of investigation measure is possible, it's not possible, the executing authority shall notify immediately to the issuing authority that they cannot execute this request in this form. Next slide, please. Ground for refusal. There was not in the Convention of 2000. There was only in the 59 Convention, plus political offenses and so on and so on. No, there is in the AEO directive grounds for non-recognition and non-execution. You will see in the timely when I speak, you have two phases. You have first, the first step is recognition of the AEO and the execution of the AEO. And you will see that you will have grounds for refusal for the recognition and ground for refusal for the execution. And you will see Article 11 of the directive say the AEO may be refused. There is no mandatory grounds for refusal. It only may be refused. When traditionally immunity and privilege, what is new now in the text is it's noted is request to the executing authority that he will waive the privilege or immunity if the executing authority is competent to waive this immunity or privilege. If not, it is to the issuing authority to request the competent authority to waive this immunity or privilege if it's not the competence of the executing authority. That's new in the text. Ground for refusal, harm essential national security interest, source of information, danger, use of classified information, and so on and so on. 3, investigating measure would not be authorized under the law of the executing state in a similar domestic case if the request is illegal, contrary to the principle of ne bis in idem, and there are substantial grounds to believe that the execution will be incompatible with human rights. So these are the 5 first grounds for non-recognition or non-execution. Next slide, please. There are 3 other. 6, criminal offense committed outside the territory of the issuing state and wholly or partially on the territory of the executing state, and it is not an offense in the executing state. It can be a ground for refusal. Point 7, does not constitute an offense under the law of the executing state unless it concerns, of course, the well-known list of 32 offenses already listed in the mutual recognition instrument, like the European arrest warrant, for example. It's the same list of the 32 offenses. If this concerns these offenses, there is no ground of refusal. Then, 8, the use of the investigating measure indicated in the AEO is restricted under the law of the executing state to a list of category of offenses. For example, in Belgium, you can only make wiretaps for the most severe crimes. This is already a ground for refusal, actually. But point 7 and 8, there is one exception. you can not use this ground for refusal for the list of the 6 investigative measures that I have shown you in a former slide. The hearing, obtaining of data in databases, and so on and so on. Important, the executing authority, before to decide not to recognize or not to execute whole or part of the AO, shall consult the issuing authority and shall request the issuing authority to supply any necessary information without delay. So again, they encourage the communication between the issuing and executing authority. Don't refuse, oh, I can do it, I send it back. No, first you have to call the issuing authority to see if you can find an agreement or to obtain necessary information that was missing. I will show you from Annex 1 where you can find the 32 offenses are not listed in the directive. They are only listed in the form, Annex 1 form, that I will show you hopefully after this slideshow. So, next slide, please. This is always very important and new, the time limits. You see in the 59 Convention, there was no time limit. In the 2000 Convention, Article 4, you shall execute the request for assistance as soon as possible, taking as full account as possible the procedural deadlines and other deadlines indicated by the requesting member state. This was the Convention of 2000. Now, for the AEO, you have strict time limits for recognition and execution. Okay. I told you that you have 2 stages. The first stage is the recognition of the AEO. I give you the best example is the Belgian one because there is already a draft of law to implement the AEO. The authority competent to recognize the AEO is the prosecutor office. So all the AEO forms have to be sent to the prosecutor office and not directly to the executing authority in Belgium, like if it is an investigating judge, for example. So in Belgium, you can have, in France, you can have an other country, member state will use the investigating judge. You have 2 authorities, the prosecutor and judges. Judges will execute. Prosecutor will receive and recognize the AEO. So there is a time limit. As soon as possible, but not later than 30 days after the receipt of the AEO by the competent executing authority. This is a strict time limit, 30 days to recognize the AEO, to accept the AEO, to control that it is completed, to control that you can execute it. You have 30 days to do that. If it is not practical, if it's too short, you can inform the issuing authority about the reason. You can inform about the reason that you cannot respect the time limit, and this time limit can be extended by a maximum of 30 days more. So the maximum delay to recognize, to accept the AEO for execution is 60 days. And then you have the second stage, the execution itself of the AEO without delay, but not later than 90 days following the taking of the decision. When you decide to accept the AEO and to put it in execution, you have to inform the issuing state, and then from this date, from the decision that you accepted, you have 90 days to execute it. So normally in 120 days, everything has to be done actually. But of course, without delay or as soon as possible, you have not to wait the 90 days or the 120 days. If it is not practicable these 90 days, you inform the issuing state about the reason, and you consult them to find an appropriate timing of the execution. So always consulting before refusal. Next, please. Okay. Time limits. The issuing authority can indicate a shorter deadline or a specific date to carry out the investigative measure. For example, if the issuing state plan horse arches in the country on a specific date, it can send the AEO form to the another member state asking horse archer the same day. Always, if it is not practicable for the executing state, always inform the issuing state about the reason and consult. You can also postpone the recognition or execution. If first case, when the execution may prejudice an ongoing criminal investigation or prosecution until reasonable time, or second case, when object, documents, or data concerned and requested as evidence by the issuing state are already being used in the executing state in other proceedings, and then until no longer required for that purpose. The executing authority shall, of course, execute and inform the issuing member state, like always, and execute as soon the grounds for postponement has ceased to exist. Next. Transfer of evidences. Okay. 59 convention was not very detailed. The AEO directive is the following. The executing authority shall, without undue delay, transfer the evidence obtained or already in possession of competent authority. And where requested, and if possible, under the law of executing state, the evidence shall immediately be transferred to the competent authority. For example, actually in Belgium, we can not transfer immediately evidence seized after a horse search at the request of our issuing member states, because the decision has to be done by investigating chamber of the court. In the AEO law, this is not more necessary. We can immediately transfer the evidence, so we respect the AEO directive, but there is a possibility, and it will be a next slide, possibility for a concerned person to go to the court and to say, stop, I don't want that this evidence will be transferred abroad. But this is no more automatic. He has to request. I will come back again. The transfer can be suspended for unless there are sufficient reasons indicated in the AEO for immediate transfer. The transfer may be suspended in that case, but the transfer shall be suspended if the transfer causes a serious and irreversible damage to the person concerned. And it's always possible to transfer temporarily the evidence to the issuing member states if it's absolutely necessary. The executing authority shall indicate if the evidence has to be returned to his country or not. Next slide, please. Obligation to inform. In the 2000 convention, you had some obligation to inform when the request could not fully be executed or partially be executed, and explain reasons. When the requested deadline cannot be met, that was it's a best practice. It's normal. But now, obligation to inform is more complete in the AEO decision. the competent authority in the executing state which receives the AO have to send, and this is a best practice but not always used at these days, but it will be mandatory. You have to send an acknowledged reception of the AO. It is the Annex B of the form, I will show you later, and you have to send this acknowledged reception of the AO without delay, and in maximum within the week on the reception. And this is a very good thing, but sometimes you send letter request and you never know if it arrives on the good place and if it arrives. No, you have to send an acknowledged reception of the AO. If it's a central authority, the central authority and the executing authority has to send this document, and if the AO is transmitted to the competent executing authority, another competent executing authority, this other competent executing authority have also the obligation to send this acknowledged or reception. Executing authority shall inform issuing authority immediately in 5 situations when it is impossible to take a decision on the recognition. When if it may be appropriate to carry out an other investigating measure than this foreseen in the AO, if it is impossible to comply with formalities and procedure expressly indicate, if you have a grant of refusal, you have immediately to inform the issuing authority, and also the decision to postpone the execution or recognition, you have also the obligation to inform immediately the issuing authority. So in this case, 5 cases, 5 situations that you have to inform immediately the issuing authority. Next. Confidentiality, that is also new, and at the head of the form, it's always repeated, the confidentiality. There was no word about that in the 59, as you see, and in the 2000. There was no article, legal provision regarding this. No, actually, in the AEO directive, it is mentioned that the executing authority shall, in accordance with national law, guarantee the confidentiality of the facts and the substance of the AEO. There's one exception, is to extent necessary, is it necessary to execute the investigative measure. For example, you have to proceed to the hearing of a suspect. Of course, you have to know about what he has to be here. You can, in sometimes, not say him what about. If it's impossible to comply with the requirement of confidentiality, notification without delay to the issuing authority. You see, always you inform the issuing authority about the difficulties, about the problems, in order to resolve them immediately. The issuing authority shall, in accordance with its national law and unless otherwise indicated by the executing authority, this is new also, not disclose any evidence or information provided by the executing authority, except when the extent that its disclosure is necessary for the investigation or proceeding described in the AEO. But then you have to inform the executing authority that it's not possible to respect the clause of confidentiality. And last in this Article 19, but I think it's already implemented in several member states. Each member state shall take the necessary measure to ensure that banks do not disclose the bank customer concerned or to other third persons that information has been requested and transmitted to another member state. Of course, this is, I think, already the case in a lot of member states. Next slide, please. legal remedies. So if you have a complaint against the measure, it's a legal remedy. The member states have to implement legal remedies against the AEO, equivalent to those available in a similar domestic case. They shall ensure timeliness for seeking a legal remedy, the same as in similar domestic case. Issuing and executing authority shall take appropriate measures to ensure that information is provided about possibilities of legal remedies. And then obligation to inform, like always, the issuing authority and the executing authority shall inform each other about the legal remedies sought against the issuing, recognition, or the execution. Practical example, in the frame of house search, at the request of a issuing member state, the executing member state sees some evidences in the house of a person, and this person can complain against the seizure of this evidence. And so he has some delay to do that, and he has the right to go to the court, and the court has to decide if he is in right or not. Well, all this has to be communicated to the issuing authority. And the issuing state shall take into account a successful challenge against the recognition of execution. A legal challenge shall not suspend the execution of the investigating measure unless it is provided in a similar domestic case. If the owner of the seized object go to the court to complain about the seizure and the transfer in the other member state, normally it's not suspend the executing of the investigative measure unless if your domestic law provide, say that it suspends the execution. Next, please. The cost, yes, not very new, but it's already the rules actually. When the executing state shall bear all the costs undertaken on the territory of the executing state, which are related to the execution of the AEO. But when the cost for the execution may be deemed exceptional high, for example, a large DNR analysis or can be very costful, then it can consult the issuing authority on whether and how the cost could be shared, and the AEO can be modified. The executing authority shall inform the issuing authority in advance of the detailed specification of the part of the cost exceptionally high. And in exceptional, if no agreement is reached after consultation, like always, in exceptional situation where no agreement can be reached with regard to the cost, the issuing authority can decide to withdraw the AEO, to keep the AEO, and bear the part of this cost that deemed exceptionally high. Next slide, please. Okay, and this is the end. This is the beginning of the end of my presentation. In fact, the AEO directive foresee also a lot of specific provision for certain investigative measures. I cannot go through that today because it's too long, but you will see in the two next slides. This is all the certain investigative measures where you have specific rules. And for example, you have sometimes specific grounds for refusal that you are not in the general ground for refusal. For example, the temporary transfer to issuing state of persons held in custody for the purpose of an investigative measure. There are two specific grounds for refusal: missing of consent, prolongation of detention. The same for the temporary transfer to the executing state. That is new. That's not very not very used actually. The issuing state requests the transfer of a person to the executing state for purpose of an investigating measure, for example, to assist for this kind of investigating measure. There are also specific grounds for refusal: hearing by video conference, hearing by telephone, information on bank and other financial accounts. Next slide, please. And you have 11 specific investigative measures who are more detailed in the respective legal provision. The banking, investigating measure implying gathering evidence in real time, for example, high microphone or wiretap, covert investigations, interception of telecommunication with technical assistance, wiretap. There are some specific grounds for refusal. I noted, for example, here, not be authorized in a similar domestic case. So you have to see the ground for refusal, the general ground for refusal, but for some investigative measure, you have additional ground for refusal. Then you have notification on the member state, and on 10, there is a specific form to use, is Annex C. And it is already actually the case when you have, for example, and in my last month at the prosecutor office, I have a lot of cases between Belgium and France and Belgium, when France put a hidden microphone in a car, and this car was unforeseen, go to Belgium. Well, France, as soon he knows that the car with the hidden microphone to hear the conversation between the driver and the passenger, for example, when it is on the Belgian territory, France has the obligation to notify immediately that there is a hearing ongoing in France, as soon as possible. Maybe he can see it only when the car is back and he reads the script of the hearing, but you have to do it as soon he knows that there was a hearing or wiretap in Belgium, on Belgium territory, without previous authorization. So this is the kind of notification. And then you have the provisional measure with the freezing and so on and so on. So the freezing order will be replaced by the AO in order to freeze evidence and to avoid the disappearance, the destruction of evidence. You have not more to use the freezing order, but you have to use the AO in these cases. This was my last slide at this moment. I would be very happy if we can go now to the, before your questions, if we can go now to the EJTN website, so I can see you, show you where you can find the form, the annexes, and the directive. It's very easy on the EJTN website. Thank you for your attention. I'm waiting for your questions. I hope you have learned something more about this new instrument that will be implemented and operational in 1 month. Next slide, maybe. And so if we can go to the EJTN website, it will be nice. Thank you for it.
We will now move to the EJTN website, to the European Judicial Network's website, and Daniel will navigate through the different options. I would like to call to your attention that you might see the screen a few seconds, with a few seconds delay due to the transmission, so please be patient.
Okay. Tell me when you are ready to go in the EJTN website. I see it already on my screen.
Yes, Daniel, we can go ahead. Please kindly let us know.
Okay. Well, first of all, to find the directive, EJTN website to find, and this is a public site, so you have not to use any password. you go to Judicial Library, you see below the map, you have below the map. Yeah, you have Judicial Library. Yes, click on this. You go to Legal Instruments. Above left, yes. Then you go links legal instruments adopted by the EU to directives, because it's a directive. And you will find on the end of the list somewhere, scroll and you find it's one of the, the 2014, 2040-41. If you can, yes, there. And then click on the English text. Okay, open with it was the other, open, yes. Okay, open. And normally the directive will appear. Yes, okay. There you have the directive. You have, first of all, the warehouse, a lot of points, general comments, the frame in which the decision was adopted, and so on. Very interesting to read. I encourage you to read this directive, the introduction, the first 42 points of this direct directive, because you have always the spirit of this AU. And then, for one, if you can go down, no, it's okay. We will move to the forms now. Okay, you'll find, can we go back to the EJTN website? Yeah, okay, go back to the EJTN website and go back to the introduction page, the home page. I show you the normal way to find legal instrument, but you can go direct to the directive. If above you have EU legal instrument for judicial cooperation. Above, yes, the second, yes. If you click there, you go at the end of the list and you have immediately the directive. It's shorter, but I want to show you a further normal way to find legal text. So it's the same, it's quicker, you can go there direct. So can we go now to the home page again, and I will show you to find the form of the AEO. Okay, we have to go in library, below the map, you have Judicial Library, okay. Then you have forms, left, the second left, yes. And here you have the complete list of the forms used in the mutual legal, the mutual recognition instrument. You have the European arrest warrant, and behind on this list, completely behind this list, on the, yes, you will find the AEO form. It is one of the news, so it is at the end of the list. And yes, and you will find it, yes, further. It's one of the last ones. Now, yes, and here you have the European Investigating Order form. You have Annex A, you have Annex B, and you have Annex C. We will go now in Annex A, in English, in Word, and you can use it in Word, so you can use it immediately in the frame of your investigation. And you have here Annex A, and you will read the introduction, reaching certify that the AEO is necessary and proportionate. It is already mentioned in the introduction, and I request that the investigating measures specific will be carried out take into account the confidentiality of the investigation. That is, and we can maybe go quickly through this document because you have some frames, section A, section B. Can we stop to section hash, like hotel, please? You will see it's very easy to fill in, and section A, F, hash, and in the section, no, sorry, it was section G. It was section G, sorry. You can go back. Okay, there you find the list of the 32 crimes that where you cannot have a grant. You are not to check if this is legal in your system. No, so this is the only. And you will see. I will now go through the document now because it's very easy to fill in. But I remember some member states maybe will use this form even with the member states who have not yet implemented the EU. But in fact, you consider then this as a letter request, and you will find even more information than a normal letter request. So it will be, you are not bound by some time limits and so on, but you can use this form like a normal letter request. Okay, can we go back to Annex B and C quickly, and this will then be the hand of my intervention at this moment. So Annex B is the acknowledge of reception. Okay, confirmation of the receipt. I remember you have to send that 1 week after, maximum 1 week after you receive this the AO. Okay, and then last annex. Okay, is the notification when you have a wiretap on the ground of a member state without previous authorization of this member state, because it was not foreseen that the car move or the wiretap was done in a border territory and so on. You have to send this kind of notification. So this was and you have okay, thank you for showing that. It is very easy to find all these forms in Word format that you can use directly. And there is also in the directive an Annex D, but this Annex D is only the list of the 32 offenses. And it's not on the EJTN website because you find this list already in the Annex. So thank you this time for your attention. I hope it was not too complicated to hear me, and that you learn something, and at least that you find where you can find, that you learn where you can find the form. Thank you for your attention, and the floor is yours if you have some questions. I will maybe not be able to answer to all, but I think it will be interesting that you will have the possibility to send later on questions on the mail address of EJTN, for example, the general mail address of EJTN, and this can be forwarded to other practitioners if I can personally not answer that. Thank you again for your attention.
Thank you very much, Daniel, for this very interesting and inspiring presentation. We will move now to the questions answers point of today, as you mentioned. For the participants, if you have questions and you would like to ask from our presenter, you may type in your questions now. It's in the same box. It's a question submission facility where you submitted your country of origin at the beginning of this webinar. I will read the questions out loud to Daniel, so he can respond to these questions. Here we have the first question. Legal remedies. Does it mean that the law of the executing state cannot justify anymore the way things are done, and that the issuing authorities have to demand that things shall be done according to the law of the issuing state? Should I repeat the question, Daniel?
Yes.
So, legal remedies. Does it mean that the law of the executing state cannot justify anymore the way things are done, and that the issuing authorities have to demand that things shall be done according to the law of the issuing state?
No. I think each member state have to implement a system that they can that legal remedies can be used in both states against the executing measure and against the issuing measure. For example, I say when the executing state make a seizure of an object, as told as evidence by the issuing state, okay, the legal remedy is possible, and the executing state and the issuing state have to take account about this with this legal remedy. And waiting the decision of the court or a judge or the competent authority who will decide about this legal remedy. And so, no, I think the question is that each member state have to implement the possibility for legal remedies against some execution measure or investigating measure. So I understand the text.
Thank you, Daniel, for your inputs. I received in the meantime another question. Does evidences must be in original, or a copy is enough?
Yeah, I think it's up to the issuing state to decide that. If they want the original, I think they have to ask it, the original. Sometimes it's maybe a lot of copy of companies' documents and so on, and the company need this original to push through the work and so on. If they need the original, I think it's the issuing state that have to mention it. If, for example, the evidence in original is already used in a proceeding in the executing state, maybe the executing state can contact the issuing state and propose him to send only a certified copy of the evidence. Of course, if it is a weapon or a car, it will be, of course, difficult. But concerning documents, I think it's an agreement between issuing and executing state. If it's false documents, in Belgium, for example, we need absolutely the original false document to go further in the procedure. And a certified copy is not enough. But it depends from domestic law to domestic law. Everything is possible, I'm confident.
We have received another question in the meantime. You spoke about how European investigation order will work from 22nd of May in countries that haven't implemented the directive, but I didn't catch it. Could you explain it again, please?
Yeah, in fact, it's very simple. Normally, all the member states, exclude Denmark and Ireland, of course, would have implemented this new instrument. But if not, you see, for the ARW, for example, European Arrest Warrant, we need a lot of time. For the JIT, we need a lot of time that the 28 member states implement this instrument. In the meantime, there is two different views. I know in Belgium, we never use the AEO form for the member states to send to member states who will not implement the AEO. But I read it in the French law that they will always use the AEO form, only the document, the form, and to member states who have not implemented the AEO. But these member states that not use the AEO can consider the AEO form, the document, as a normal letter request without be bound by any obligation in the IAO directive, because they have no law at this moment. So they can consider it only as a form, a document. And as I say, in this document, you will find more information than you find in the normal way in normal letter request. For example, I know that sometimes with Switzerland, we send a European arrest warrant forms, and of course, Switzerland don't use ARW, of course, and they consider this ARW form as an extradition request. So it's only a document, and without links to obligation in the AO. I hope my answer is clear.
Thank you, Daniel. We have received quite many questions, actually, so we will only have time to respond 1-2 more. If you agree, I read one more question.
Yeah.
How does the European investigation order relate to Naples II Convention, the Convention on Mutual Assistance and Cooperation between Custom Administration? Does the European investigation order also replace Naples II concerning investigative measures?
Yeah, I remember when I was in a work group in Belgium to draft a text of law for implementation. This was a big question, and it will depend from member state to member state. In the text, Naples II is not mentioned as be replaced by the AO. So from my concern, the Naples II will continue. The only maybe answer you can find, but it is the types of proceedings, but be in the slide number 8, the question of proceeding brought by administrative authorities. And so it's foreseen, but it's a difficult question. And in the work group in Belgium, we had some representatives of customs, and I know this was a difficult topic. And honestly, I cannot give a correct and complete answer now. But as I suggest, would it possible that the question that cannot be answered now will be sent to an email that I can eventually answer or forward to competent colleagues?
We have another question here. Is it still possible to send or use the old LOR?
Yes, it will be absolutely possible with the member states, between member states who not implement the AEO. For example, Denmark, Ireland will never implement this because it was such declaration in the directive. So with Denmark and Ireland, the other member states have to use the normal letter request. And so this will continue, of course, and also the freezing order for evidence, freezing of evidence, all these instruments, and also the member states who implement the AEO with another state who would not implement the AEO will use the normal letter or request. But it can be, as I say, the AEO form, only form, that's all, to make it simple.
Thank you, Daniel. We received a question from France concerning transmission of European investigation order. We wondered if the Interpol channel could still be used to send EIOs, and if yes, in which cases?
Yes, of course, it's not forbidden to use Interpol. It's only a facilitator. But my concern is that inside EU, because we have EJTN, because we have other direct channels, I don't see really the necessity to go to Interpol. But it's of course not forbidden. You can send police to police a letter request. The only concern is that the AEO form has to be signed by a prosecutor, by a competent authority, by a judicial authority or similar authority, everything is possible. Sometimes, and in Belgium we did it, we can already execute a letter request actually without have the original, have only the signed copy, but when we have to go before the court, we need then the original. So I don't think that Interpol is very useful inside EU, but you can use it, of course, if you my always suggestion is never use 2 channels or more than 1 channel in one time, before that will complicate everything. If you choose EJN, use only EJN and waiting the results, and then choose another channel if not, but never use 2 or more channels together.
Thank you, Daniel. We have another question. If one country has implemented the directive and another one not, which instrument should be used?
Well, clearly, that is the difficulty. Normally, in the best world, this will not be a problem because every member state outside Denmark and Ireland have to use the 2000 convention, of course, because you have to use the legal instrument common to the 2 states. You cannot use for the issuing state is based only on the AEO legislation and the other on the convention of 2000. You have to use always a common legal basis with all the executing and requesting states. For example, for joint investigation teams is exactly the same. We make joint investigation teams with 3rd countries outside of the EU. Well, in the convention, together, it's just an example. It was a joint investigation team between 2 member states and 1 3rd country. Well, in the joint investigation agreement, we have to mention the convention about JIT, the 2000 convention, and also the 2nd protocol of the 59 convention. So you have always to use this common legal basis.
And now we have one last question. I am quite concerned about the rules for gathering evidence. Can the issuing state ask for a specific way to gather evidence? This would be very important for the use of the evidence during the proceedings in the issuing state.
Yes, it is foreseen, and it is. I hope that the audience can have the PowerPoint because it's an interesting document. Yes, you can ask specific measure, and the executing state has to follow that if it is not against its law, its national law, and against public order. Then you can, of course, request to the executing state to follow some rules in the procedure. For example, a specific witness during a house search or whatever. And if it's possible in the frame of the legal system of the executing state, he has to answer and to respect this request. Of course, if it's not legal in the executing state, of course, it will not be possible to follow. But the executing state has to do a maximum effort to answer to the request, completely to the request and specific measure of the issuing state. That is, of course, possible. It was so in the 2000 convention already.
Thank you, Daniel. We thank you for your questions. We hope we covered most of them, and I hope the responses you received were quite clear. In case you have concerns or further questions, please don't hesitate to contact us, and we will get back to you. Thank you very much for participating in this webinar, and very many thanks to Daniel for his excellent presentation and interesting insights and perspectives. We now close our EJTN pilot webinar, the European Investigation Order, Perspectives and Challenges for Practitioners. We truly hope you found this a stimulating and value-adding event. When leaving the webinar, please do not forget to complete the evaluation form, as your feedback will help shape EJTN's future webinar program. Many thanks for that. And if you are able to, please join us again tomorrow at 11 a.m. for EJTN's second pilot webinar entitled The Wrongful Removal or Retention of the Child. Now we thank you, and from all of us and the EJTN and the CEPOL, we wish you a pleasant afternoon.